It is March 30th of 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. Today we'll witness a defendant who dares to insult his own lawyer in front of Judge Stevens. A simple eviction case with Judge Dad spirals out of control when Judge McNally discovers an active warrant for the tenant. Then will be a fly on the wall as the defendant's desperate, incriminating jailhouse phone calls are played in open court, sealing his fate. Finally, we have what I think is a feel-good case with Judge Mogan to end things off on a hopeful note. From raw emotion to shocking revelations, grab your refreshments, ladies and gentlemen. Buckle up. As always, it all starts right now.
Then there's David Wiggins.
Judge, I have filed a motion to withdraw on that case. He is... It's a motion to revoke probation, but he's very hostile with me whenever I try to speak to him. He speaks to me in a very...
Should we bring him out? Let's bring him
What are you
out.
gonna do, Judge?
Wiggins. Well, I mean, we can do this forever. But I'm not gonna let him do it.
Just given the communication barrier, I just...
Well, he's gonna do this to everybody,
And I don't know.
theoretically.
I don't know if it's me specifically or if it will be
Come on
different
out.
with...
23 CR 1479 is called David Sinclair Wiggins. That's you, sir? You're Mr. Wiggins? You're charged here. There's a second amended motion to revoke probation that's been filed. And as of October 17th, 2025. These things essentially allege you failed to report to the probation office, it looks like in most of this, and failed to immediately report change of address. And then you're behind in fees.
And Judge, I have this paperwork as well,
What is this?
just in case you need it.
Ms. Minaldi, here's one of my court officials. She's a public defender. Are you having problems with this lady? She says you're rude to her.
Go through without the doors.
I don't put up with that. If you are rude to her, I can hold you in contempt and add some more problems here, which I don't want to do. But can you be civil with her and act like a gentleman?
Yes, sir.
She has filed a motion to withdraw and she never does that. But I'm not going to tolerate rudeness. And she's a very nice lady and she helps her people. She works very hard for the people she represents. But she's somebody I appointed. And when you insult her, you insult me. I would like y'all to try to work this thing out if possible, but I want to know immediately if he is rude or abusive in any way to you. I'm going to hold this motion. I'm going to take your word right now that you can be civil and a gentleman. And this is your life. She's helping you. She tries to help in all cases. Then you are looking at up to 10 years in prison here, sir. You don't need to make enemies with the people who are trying to help you. Would you agree? What are we going to do with this?
Judge, I don't know, I was able to have a meaningful conversation about his options with him yesterday. there's an offer on the table,
All right,
if you would like to
Would
have
you-
discussions about it today, I don't mind stepping in the back
All
and
right,
trying to speak
all right.
with them.
let's try to see where this is heading. You have, sir, these are 8 violations, but they're essentially, he just didn't report. Huh? Well, if you walk off the job, you get fired. You got to report. Probation is all. If you can't do anything, you've got to report, or else you're not being supervised. And that's what probation is all about. And I mean, you could commit crimes and those are serious, but if you're not showing up for work or probation, you're not on probation. You're on your own probation, which isn't the way it works. I lose track of supervision over you, but she is the person who's going to guide you through this problem that you've gotten into. It's like a minefield you've fallen into, and your probation, like I said, you're looking at up to 10 years in prison here. So you've got to negotiate through this problem responsibly, which means working nicely with the person who is your lifeline. Can you do that? And promise, if I find out, she's a very honest lady. She never files these motions. She would only do it if she felt that you had not treated her properly. And I'm going to trust the way she thinks. Fix this mess. But don't hesitate to let me know if there's a problem.
Okay,
And then
we're gonna step in the back,
we'll do-
Judge, and see if we can.
Okay, let me deal
You'll
with
just
Mr.
give me
Burbank's case.
15 minutes.
Thank you. Okay. Mr. Burbank, come on up. Jeremy Johnson,
Yeah, sure.
what are we going to do on that? Jeremy Johnson, that's you? Come on in. 25 CR 1907. You're charged, hello. Charged with a second-degree felony of aggravated assault with a deadly weapon, but that's not the ending of that story, is it? You got 1, 2, 3, 4, 5 prior convictions alleged. And if this is all found true, if you're convicted of the second-degree felony, then those are 2001. That's the same time, isn't it? Wow. I don't remember that. I remember something like that.
Judge, you're gonna have to speak up.
What'd you say?
Exactly. He
You're,
doesn't have his hearing.
you're looking at a second-degree felony. Can you hear me? Well, what am I supposed to do? Can you hear me?
No, yeah,
Okay, you're looking at, because of your prior convictions. I don't normally use a megaphone like this, but the man has a hearing issue and he's not wearing his hearing aid. You're looking at first degree felony punishment. You're looking at up to life imprisonment. Do you understand?
yes, sir.
Serious. What's that?
I'd ask you to please take a look at the bond, Judge.
What is the bond right now?
$300,000 plus a GPS device.
I'm sorry, is 100,000?
$300,000 plus a GPS device.
Let me look at the probable cause affidavit. Do you have a public safety report by any chance?
Judge. I didn't get noticed, but
Yeah.
I'm okay. I'm prepared to
In
go forward.
February.
I didn't get
February
noticed.
20th.
See notice. I'm serious. I'm looking. I would tell.
Your office.
Well, it's not in, processes.
Okay.
Okay.
No.
Fine.
Yeah, it was filed in.
We didn't receive this. But it's fine.
Well, what I do know is I've looked at the probable cause affidavit here, which is obviously charging the defendant with aggravated assault with a deadly weapon, namely a firearm.
I think it was a pellet gun, Judge.
I don't know, it says a firearm, and in the probable cause, it says a firearm, doesn't say what it is. I don't know, but this is at about midnight, it looks like. And is moving around here at this apartment. Or it's a rental property here in Beaumont.
It was a residence.
Residence, it doesn't, it's not clear what it is, but you've got photographs and video here of the defendant. The problem is this is at midnight and he's got 1, 2, 3, 4, 5 prior burglary of habitation convictions in paragraphs 2, 3, 4, 5, and 6 and out of this court.
Judge, I believe it's 6
What year was it?
priors.
Yeah.
1, 2, 3, 4, 5, 6.
That was a long time ago.
Yeah. 1, 2, 3, 4, 5, 6 prior convictions in 2001. Yeah.
And I questioned the attorney back then, but it must have been a plea deal. For all those at the same time, but I don't believe that he's really been in any.
What was his sentence for those?
10 years.
10 years. Oh, okay. All right. Then here at midnight, well, you can imagine we're he's alleged to be lurking around somebody's residence at midnight. And did he have a firearm? Is it showing? He's alleged to have a firearm, a deadly weapon, namely a firearm.
It was a,
Why wouldn't he charge with felon in possession of a firearm also?
it's a pellet gun.
Well, I know you say that, that's not what it says. Have you
Why
seen the
not?
probable cause?
Uh,
It says a firearm.
I kind of know it's a pellet gun.
Well, nonetheless, it's capable of causing serious bodily injury or death. So it's a deadly weapon, even though it may be a pellet gun. Doesn't have to be an AK-47. It can anything that can cause serious bodily injury or death, which a pellet gun can shoot your eye out, which is serious bodily injury to anybody who's had their eye shot out by a pellet gun. Anyway,
There is a
what else do you?
yeah,
What do you?
There is a requirement for GPS. He does have a place to stay, so you can kind of confine him.
Where was he on this? You didn't have a place to stay on November 1st?
Which was in the house.
From across the street.
Anything you want to add on why he was lurking around at midnight? I can't tell. It doesn't say what he was up to, but it obviously frightened the people who were there.
Well,
They thought,
the way I read the PC, Judge, was that there was a sensor outside that picked him up outside.
yeah, a Ring camera.
Right, going through the yard.
In the backyard.
Mhm.
Or is this a gated area? Enclosed backyard? I don't know. It says
Doesn't say.
2 males. One of them was armed with a firearm. Doesn't show who it is. It doesn't say. Authentic is. Somebody from the house, I guess, confronted them while attempting to get them to leave the property. The shirtless man with the large 59 tattoo on his chest pointed the firearm at the victim. Is that you? Do you have a
59 tattoo?
Do you have a tattoo?
It's hard, Judge. Do you have A 59 tattoo?
Yes, sir. We was in Columbus State, they know me, that's crazy. It was all, it was like,
No, according to this, he threatened to shoot the other guy. Well,
That's how I read it as well.
yeah, nobody, and when at midnight, when somebody's in your backyard threatening to shoot you and has a gun in their hand, you're not gonna negotiate a truce. You're gonna flee for your life. Oh, that doesn't sound good. And the prior, six, not five, but six prior burglaries of habitation.
Oh, that was 25 years ago, Judge.
I was a kid, made a mistake, and I dropped him outside.
Come here. It's a famous saying. Very smart man said this. What's in the past is never really ever in the past. It's always there. It's still there. Even though it was a while ago, it's still there, and it plays a part in this because even 25 years ago, this will increase your punishment. It's still used. It's not too old to be thrown in the trash. It's still going to be part of this case. So that's why I tell people, don't commit crimes because the past comes back to haunt you. Right. Yeah. What are we gonna do?
I'd ask that if you would consider 75,000, Judge.
What's state say? It's
I will, of
300,000
course-
right now?
Right. I would, of course,
Yeah, he has a GPS device and you can put confinement at home.
I would defer to the court, however, I just would like for you to consider the safety of the community.
I-
The guns is used.
I always will.
And
What are you suggesting?
I suggest that the bond amount, I mean, I'm gonna defer to you, be reduced to no more than $100,000 or $150,000, whichever you feel is just.
100 or 150?
150 with an ankle monitor, of course. But it disturbs me that a gun was used and he allegedly threatened the homeowner to shoot the homeowner.
I'm gonna chop it in half to 150,000 plus a GPS. It's his criminal history. His criminal history and the circumstances of this offense are
You wouldn't consider
disturbing.
100?
Disturbing.
Her first try, 100,000, Judge?
It's up to you.
Actually, I was.
A possession of a.
I mean, if you could read my mind, it was 150. I thought I would chop it in half,
Mhm.
but where are you going to live if you get a bond? Where do you live?
Where you gonna live?
Going to live with me and the kids, I took care of the kids, you know,
How old are your kids?
17, 12, 10.
Oh, yeah. You got children?
Work, yes, sir.
What are you doing at midnight with your children or at home?
Oh, it's wrong place, wrong.
You were in the wrong place at the wrong time?
Yes, sir. Came from my bar.
Well, it ended up in an indictment. Okay. You got children at home. Come on. You got important responsibilities.
One mistake can lead to this.
Sir, there are 7 mistakes in here, 7, 6 prior convictions, and then this one. Come on. This is 7. You gotta stop making mistakes that get you in this room. Oh, what's the next event?
Finish up the
Announcement.
recovery, Judge, and then
Okay.
an announcement.
4 weeks
That's fine, Judge. I have another matter.
with him?
Yes,
Go ahead.
his wife or his girlfriend has his hearing aids.
Okay.
And I can't communicate with them except yelling like, so everyone can hear me in jail.
Yeah, I understand. What do we need to do? What can I do?
I think if I can submit a court order, that I can tender those hearing aids with that court order to the jail, they can inspect them or do whatever so that he can get the hearing aids so I can
Communicate.
communicate and defend my client. No, they're with the girlfriend, right?
Or what?
Wife, common law wife.
How long have you been wearing hearing aids?
2 years now.
Okay.
He worked at a plant and
Where plants 18 years, 19 years, so I became a victim of that hearing aids.
Okay.
so if I submit an order to you, allow me to
Yeah.
defend with it.
Yeah, yeah. The right to an attorney isn't effective if he can't hear.
You firsthand, Judge.
What'd you say?
You understand me?
Put loud and clear.
Yes, Your
Anything else? I'll do that.
And you'll reduce their bond down.
150,000 plus GPS device.
Yes, Your Honor.
Thank you.
Thank you.
And don't commit any crimes. If you get out, don't commit any more crimes.
So
We'll set this in 4 weeks. Anything else? That's all, Tom. Thank you.
Thank you, Your Honor.
Anything else?
Judge, can I read a vote on Wiggins?
What do you want to do?
Is, I was able to discuss my options with him, and he's saying he wants to voluntarily be true. And have you assess.
Okay, I just have to be
It's like, that's not, if you want to do it, you want to reset it a week.
No, can I do it tomorrow?
What about Wednesday? I'm here Wednesday afternoon.
Wednesday. We're gonna reset Wednesday.
Wednesday afternoon.
Okay, 'cause I've got a meeting I've got to go to right now.
Okay.
It's the same.
But we'll bring Wiggins back and move on that. Or is there an agreement with the state or?
There was an offer, but he seems to want to go unagreed and put through.
Okay, I'll do
Make
that.
sure that he understands all of his options on the record, and then we'll do it Wednesday.
Okay, thank you. All right, bye-bye.
I'm gonna call Douglas Heckert Jr. versus Amanda Potter and Eric Velke Jr., 2601222.
Morning, John.
Hello,
Good morning.
good morning.
What's your name, sir?
Douglas Heckert.
Mr. Velke, you gotta start your video. Ms. Potter, state your name.
Amanda Potter.
Mr. Velke, your name.
Eric Welke.
So what's going on here, Mr. Heckert? You sent them a notice to quit?
Yes.
Under what circumstances are they staying in your property?
Good. I've been friends with them for a long time and, they haven't been able to keep up with their rent.
Do you have a written lease with them?
I didn't at first, but I made out a new lease agreement with them and had them go over it and sign it. And,
See, you're trying to do some, okay, when did they sign the lease?
yesterday,
You're trying to do something and, you sued for. I don't know what to do. You gotta be careful. I don't know why everybody thinks they can do this properly. Now, you've sued them for termination of tenancy, which has nothing to do with them being unable to pay the rent.
right.
And you could have asked for me to give you a judgment today, asking for them to be out by April 9th. And now you're telling me you entered into a lease agreement with them?
It's never really been a lease agreement. It's been
No, listen, did you not tell me yes,
yes.
yesterday?
Yes.
What are you doing?
Trying to, they want to be able to stay. And they have so much back rent that they owe. And I had made a agreement to where they can stay and I will not evict them as long as they abide by the new lease that I had given. The first part of this, when I filed.
You're trying to be your own lawyer and you're not doing very well at it.
Right.
What do you want to do with this case? Dismiss it? Now you got a regular termination, a regular lease, and now if they don't pay, you can send out a 7-day notice to quit and you can have them evicted. I'm just telling you.
Right. So, yeah, pretty much.
I don't know what pretty much means. Do you want to dismiss this case? You guys,
Dismiss this case, and then if they break this lease agreement, I will be back.
you're gonna have to file it separately. I'd suggest you get a lawyer. It should be for non-payment of rent if you just entered into a lease. How long's the lease? 1 year?
No. And
You need to talk to a lawyer. I'll be glad to dismiss this case for you. If that's what you want, everybody agrees to it, I'll dismiss the case. Is that what you want?
Yes, I also have a question.
Okay, I wasn't really talking to you yet. I'm asking him. Is that
Oh,
what you
I'm
want, is to dismiss this case?
matter of fact,
Oh, come on. I don't know what you want out of me. What, I can't, you just entered into a lease agreement with them. You're trying to do something you have no business doing. This isn't a small claims action. You just don't have any business doing this. I don't know what you want me to do. It doesn't sound like you guys have been fair with him, though. I can tell you that if you haven't been paying. How long since they paid you rent?
I haven't had received, they're pretty much like 10 months behind.
10 months. Wow.
That's completely wrong.
$600.
What a great country when we can get 10 months of free rent. I hope my bank's gonna give me 10 months of free mortgages. How much you owe him, Ms. Potter, Mr. Velke? What are you guys doing? You taking advantage of a friendship, or you guys just not
No, we're
going
2
out and
months,
working?
we're 2 months behind rent.
Well, you,
They are not too much money.
so wow, you guys are quite.
They have a balance of $3,000.
We're not gonna go there. We owe money. We know how much money we owe. We signed an agreement, plain and simple. That's
How much do you owe, How much do you owe, Mr. Velke?
$3,400, and it's more than just rent. It's for other things too. It's personal.
How many
things.
months are you behind on rent, Mr.
10
Velke?
months of rent.
2,
6, I'm sorry?
2.
How many months are you behind on rent, Mr. Velke?
We haven't paid anything in 2 months.
Just 2 months. You guys are off. How you accepting your payment? This is what I'm talking about. You taking it in cash and not giving receipts? Are they giving you money orders, certified checks?
Yes.
No.
Nice, nice. Let's make sure we really complicate this. I mean, seriously.
I mean, I tried to do it. I tried.
Well, you didn't do a very good job. You're hurting yourself. You cannot be your own lawyer. I mean, you
I'm not
can't.
trying to be my own lawyer. I'm trying to help out some people and they're taking advantage.
Well, I mean, that kind of seems like that to me, but you got a warrant for your arrest, Mr. Velke. You know that? I know, everybody's always so shocked. Like it couldn't happen to me. I've been a choir boy. Where haven't you shown up on your warrant?
I don't even know what you're talking about. How old is this?
Don't know, Mr. Velke. I just do what people ask me or inform me of, and they just told me you've got a warrant out for your arrest.
I have no clue. I had a
Yeah,
meter warrants. I took care of most of them.
most of, oh, okay. I want you to tell me what that is, Linda, or somebody over there. You got one in front of Judge
I'm sorry, Your
Heston?
Honor.
What is it, for unpaid fines?
I don't know. Sorry, I didn't catch what you were saying.
Don't worry about it. How much, oh, you got a 5,000, 10%. Do you work, Mr. Velke?
No.
Why not? You're not disabled, are you?
No. I do like odd jobs here and there. I'm looking for back full-time employment.
All right, listen,
All right, Judge, their rent is $400 a month.
I don't,
And they're far behind. If they're
What?
trying to state that they.
sir, you got a mess.
Yeah.
You've got a mess. I'm not addressing non-payment of rent. You didn't sue them for non-payment of rent.
Okay,
You sued them to have them evicted because of termination of tenancy, and then you, for whatever reason, decided to go enter into a lease agreement with them yesterday. I don't know what I can do here. If you've got a valid lease, you have no right to evict them. The only thing I can do is dismiss this case. You need to get a lawyer helping you, sir. I mean, I don't know what the situation here. I feel bad for you. I really do.
Stating they're only 2 months behind, I just better go through with the proceedings of having them
You,
evicted.
you can't. You just entered into a lease agreement with them. You guys aren't being honest. I can tell. I can tell by talking to you. You're not being honest, neither one of you. Shame on you. Shame on you. Do you work, Ms. Potter?
I'm on disability.
You guys are not being honest with me. I'm just so confident that I can say that. I can just tell you're not being, don't act like you're a choir boy, Mr. Velke.
I don't know.
I expect you to come up here and take care of that warrant in the next 2 hours. You understand?
Wait, what?
Wait, what? I expect you to come up and take care of this warrant that's been outstanding for almost 4 years now. Are you with me? Today, within 2 hours. You're not working. You're not doing anything. You're sitting at home. I expect you to come out here, and don't be shocked if you don't, if I call the police and say, go pick up Mr. Velke, in which case we'll get around to hearing the case when we feel like hearing the case. So here's what I'm doing. You don't leave me any option. I'll give you a 1-week adjournment and you can talk to a lawyer. How's that? But you better do it because you're really making a mess out of this thing so far. April 6th at what time?
9:30, Your Honor.
At 9:30. I would strongly suggest you do that, Mr. Eckert. And I'll just make a note. You could have terminated the tenancy if you didn't get the wise idea of doing that lease yesterday.
I only did it because they had nowhere to go.
Listen, I commend you. I think you're a nice man. You seem like you're very nice. You're trying to do some friends favors, and this is the problem. They're not really friends. They're not friends. Friends don't do this to friends. So now you're starting to take matters into your own hands. You're executing lease agreements. I don't even know how good or bad it is. I'll adjourn this 1 week. Is 9:30 okay, Linda?
Yes, Your Honor, that's perfect.
April 6th, 9:30. I'll tell you what, Mr. Velke, if somehow, some way you don't get up here in the next 4 hours or 2 hours, Mr. Velke, to appear in person, you are to be here in person next week. So if I were you, I would come up here and I would take care of that warrant by 1 o'clock at the latest. It's about 10:43 right now. You understand what I'm telling you, sir?
Yeah, I'm going to work today, so I'm gonna have to.
Mr. Velke, I can only tell you, do what you gotta do. I'm only telling you, if I were you, I'd get my tail up here and you take care of that warrant by 1 o'clock. Don't tell me this, I'm going to work today. You're not working. You just got done telling me that for the most part.
I told you I have to decide that.
Mr. Velke, Mr. Velke, I will remember you. You will be here in person next Monday, or I'm going to send them out for you. And you're going to end up defaulted on this case. I'm not going to argue with you. I expect you here in the next 2 hours. Good luck. We'll see everybody next week here at that designated time.
It will be Lawrence Goddard, file 25-93374FH for sentencing and contempt hearing. Counsel, you want to state your appearances, please? Beginning with the people.
Jeremiah Buffalo, work on behalf of the people.
Good afternoon, Your Honor. Christopher Price, P84943 on behalf of Mr. Goddard, who is seated to by right.
Okay, good afternoon. And we're here for sentencing, and also we've adjourned it a couple times, and most recently then so that we could give the prosecutor an opportunity to go forward with a contempt allegation. Mr. Virgo, ready to proceed on that?
I believe so, Your Honor. We have some audio to play. We were getting a little hiccup with our IT. Of course, our machine check. This thing takes forever to load, Your Honor. So I've got my flash drive, but I have no means to play it. We're in an IT hole right now, and we literally don't have a laptop that is functioning right now.
But it's warming up right now as we're speaking.
We're dealing with laptops that are older than me in some situations. It seems it can literally take 10 to 15 minutes for them.
Mr. Parks, you've been provided with a copy of this?
I have, Your Honor.
So your proofs are going to consist of an audio of a phone call from the judge?
3 separate calls. We pared it down to Your Honor, though I would indicate that those 3 calls together are around 34 minutes in total length.
And you, Mr. Parks, do you have any objection to the court's receiving and considering those?
I do not, Your Honor. The only objection I have is the context from whatever audio Mr. Virgo was playing, in which case I would like to call my client to clarify any issues.
Then, so that we have a good record, you're gonna mark that as an exhibit and we can have that in the court file.
Yes, Your Honor. The thumb drive is the court's.
And that'll be marked then as People's Exhibit 1. You have no objection to the admission and publication for the court of Exhibit 1?
I have not, Your Honor. I also have a, depending on what audio people play, I also have some audio to play from. It would be the same jail calls, Your Honor, just perhaps different calls that were made, so.
And if I may, Your Honor, for the record, this would consist of 3 phone calls. One of those calls being from November 5th of 2025 at 8:35 p.m. The other being on 11/17/25 at 11:13 a.m. And the third one being 11/23/25 at 10:02 a.m.
What was the last one?
Last one was 11/23/25 at 10:02 a.m. And I did not, I didn't shorten them or reduce them. Those are the calls in full as we got from the court. I would note, I do believe, Your Honor, that there is a stipulation as to the authenticity and foundation of those.
And you both believe that I need to hear all 34 minutes. There's not excerpts that you want to queue up and direct my attention to, or?
Your Honor, from the defense's perspective, he's not denying that he had contact with his wife. You're going to hear his voice and her voice on there. The issue is the context that the people are trying to present, that he's trying to convince her to do these things. And if the court's inclined to hear the entire video or entire audio, then yes, absolutely, my client should be able to at least explain himself as to that. And the context is what's going to matter, unless the court wants to just rule that he had contact with her, and that in itself is a violation, which if that's the case, we have no objection, Your Honor. The people have already said they're not going forward with any future felony charges based off of the phone calls. So I'm not entirely sure what all, what the end game is when he's already admitting that he's had contact.
So, Mr. Virgo, if the, yes, is it relevant for me to hear all of those then?
I believe so, Your Honor. There is an implied tit for tat. There is offers of a vehicle and providing a vehicle, along with inducing to write a letter for this court. That is the onus, and I do believe that that would potentially form grounds for this court to deviate upward from the sentence guidelines.
Or if the facts come in as you've alleged, I suppose that could support a score under OB 19 for attempting to interfere with the administrative justice.
I believe it would as well.
All right, and Mr. Parks, violating the no contact provision alone would not warrant scoring OB 19, correct?
Correct, Your Honor. It would give the court the ability to give contempt for Mr. Goddard for violating this.
And so the prosecutor said they wanted to have this hearing to inform the court's sentencing decisions, and that could involve OB-19 as well. If there's some attempt to influence testimony or something, or discourage testimony, that would be scoreable under OB-19. So I think, I guess we do need to hear them. So, okay. So are we ready to play now?
Connected. This call is being recorded and has a maximum call length of 30 minutes.
Hey.
Hello?
Hey.
So before we play that, I am providing enhanced public access through the live stream. Before we start playing this, are there parts in this that are of a nature that we shouldn't be doing so?
Curse words, Your Honor, but
Okay.
that's
Nothing that would cause any difficulty for a complaining witness, or?
I don't believe so, Your Honor. I
Okay.
believe the complaining witness has been present in the court on numerous occasions.
Okay. Will you agree with that, Mr. Parks?
I would, Your Honor. I don't see the complaining witness in the courtroom.
But I mean, there's no portion of this conversation that's of such a private nature that we should.
I don't believe
in the live stream.
I don't believe so. Your Honor.
I don't think so, Your Honor, but if we could approach, just in case it is, I'd like to tell the court on a sidebar real quick.
Okay. All right, and after conferring with counsel, I don't see any reason why we can't go ahead and continue. I'm not sure your shared screen might have ended. So. Unplug it again.
Call is being recorded and has a maximum call length of 30 minutes.
Hey.
Hello?
Hey.
How you doing?
I'm all right. How are you?
All right.
No, not really.
No?
No, I was talking to somebody else. He asked me if I was watching something on TV.
Oh.
How are you?
Ow. Fine.
Yeah. Good. Get a hold of mom.
Yeah, I tried to talk to Marie yesterday. She
Yeah.
don't want nothing to do with me.
Why?
She told me to change my address.
Why?
What do you mean why? I don't know why. That's how she's been.
Huh. Well, I'll try talking to her later. I tried to call. She wouldn't answer for me.
No, Sandy said you're not going back there.
Huh?
Sandy said you're not going back there.
Oh yeah. Who said that?
Sandy.
Sandy's not the one. Mom already told me I could go back there. I don't understand where Sandy's getting her information from.
I don't know.
I'm not going to cause a pissing argument from it anyways.
Right.
No, I'll buy the motorhome. Just got to put fucking gas in it.
Yeah.
Yeah, you can go stay there if you need to. Are you okay?
Yeah, I'm all right.
Well, are you okay?
I'm okay.
Okay.
Probably gonna go stay in Gaylord. That's where all the jobs are.
No. When I get done, we'll talk about all this. And don't shut me down. I'm just making a statement. Things would be different.
I gotta do what I gotta do. I gotta live.
I'm telling you right now, go to your mom's.
Well, I'm telling you, I went over there yesterday and she gave me my mail and told me to change my fucking address.
Really?
Yes.
Wow. You went over there?
Yeah.
Okay, I will call her when I'm done talking to you.
I picked up the truck.
Huh?
I picked up the truck.
Oh, you have it?
Yeah. We took the tools and stuff out of it. Sandy did. You there?
Yeah, I'm here, I'm listening.
You keep breaking up.
No, I'm not breaking up, it's you're breaking up.
Well, I don't have a problem unless I'm talking to you, so it's not me.
Oh, it's this phone here then. Oh, don't lose my truck.
Not gonna.
And don't, hey, I need you, when it's time for me to get out, you need to be somewhere where I can be picked up.
I know.
Don't fuck me around. Don't have insurance and the plates aren't legal.
I'm gonna transfer the insurance and plates from the car onto it.
Are you?
Yeah. I'm gonna do that tomorrow.
Oh, yeah? Okay.
I'm gonna try to. I don't know it's not my name, but I'm gonna try to.
Well, if you need to have me sign something, I can sign it, whatever.
I think I should be able to because I'm your wife. I don't know.
Should be able to. Well, you shouldn't say that either.
Right. Sorry.
No, it's not your time, it's mine. Just more of it, it don't matter. All right, I gotta go. We'll talk to you. Have a
Are you
good night.
fucking serious?
No, I'm not serious. Why would I be serious?
All right, Larry. You have a good night.
I'm trying to talk to you, and you gotta watch, you know. Come on.
All right.
So have you considered the letter?
Yeah, I don't know what to write. I don't know how. I don't. And what do I say?
Call the lawyer. Call my lawyer. His name is Chris Parks. Here, I'll give you a number.
So how did you message me on WhatsApp?
Don't worry about that. I got
I'm
lucky.
looking for a pen. All right.
And his name is Chris Parks.
Chris Parks.
Yep.
All right.
Just ask for him. Tell him you need to talk to him. And when he talks to you, ask him what you need to put in there.
All right.
So anyways, all right. I'm gonna call Mom.
All right.
Behave yourself.
All right. You too.
What am I gonna do?
Well, I don't know. I almost got in trouble in there.
I ain't getting in no trouble. Ain't nobody fucking with me. I actually made some friends.
Good.
Yeah, gonna have to have somebody when I get out of here.
Okay.
I love you. I hope you have a good night. We'll talk to you. I'll call you in a couple of days.
All right.
Sometimes I might just ring you, let you know I'm thinking about you. Okay?
Okay.
Did you write down that thing, that CID?
Yeah, it's like $91 a month.
$91? No, there ain't no way.
Yeah, it is. It's like $2,000 a year.
CIDOS?
SIDOS at .net.
CIDOS. Not
CIDOS.
CIDOS.
All right.
You got a pencil in your hand.
Okay.
Yeah, it shouldn't be no fucking $2,000 a year. I should be able to pay for it here and get a hold of you there. All right.
CIDOS.
CIDOS. It's a capital OS. Capital O and S are capitals. O and S are capitals. All right. All right. Talk to you later. Have a good night. I love you.
All right.
Okay. Thanks.
I love you too, Larry.
All right. Bye.
Bye.
Okay, and then we can do call 2 on November 17th.
This call is being recorded and has a maximum call length of 30 minutes.
Hi,
Hello.
how are you?
All right.
Are you? Good. What's going on with you?
Eating nachos.
Yeah,
Homemade nachos.
good. Sounds good.
Basically Doritos and cheese with some olives.
Yeah. Well, I'm glad you're eating. Glad you got what you need. I hope you got what you need anyways. You talked to my lawyer yet?
No.
You need to talk to him about what do you need to write in that letter for me, please? I'm not trying to push you. I'm not trying to, how do I put it? Influence you either way. You need to write a letter for me if you could. Something positive that would help. If you could do that for me, I would appreciate it. All right.
How are you?
Huh?
How are you?
I'm fine. I'm gonna be okay.
Tyler come visit you yesterday?
Huh?
Tyler come visit you yesterday?
Yeah, Tyler come and see me, brought me a thermal shirt. So when I go outside, it's not so cold. He was supposed to bring me some pictures. He asked Mom to print them off, but of course they didn't get that done for him. So I doubt if I'll get them. But that's all right. It is what it is. But the reason I'm asking you to do that sooner is I'm gonna push my lawyer to get me sentenced on the 1st. So I can be eligible for Sheriff Good Days and anything. They have work days that they can do where they take guys out of here and you can go get a day for a day, you know.
Right.
Get out a few days early and not have to spend the complete holidays in here. If you understand what I mean, every day is one day closer.
Right.
No, I'm just trying to get my shit done so I can get out and go back to work. Start doing my probation. That's all I want. It's dead time. It's basic dead time right now. So I'm in my Bible, praying, studying, trying to get my head together where I need to be, what I got to do and who I got to be when I get out. You know what today is, don't you? Did you hear me?
Yeah, I heard you.
You know what today is, don't you? 10 years ago today, Dad passed away. We were on our way into Rogers City. He died away. We got that phone call.
Don't do that to yourself.
Yeah. I've done this to myself for days, months. I've been beating myself up bad. I regret a lot of things. I have a lot of regret. I'm trying to forgive myself for everything I've caused everybody. I see it. I'm going to change and be different. I'll be a different person when I get out. Hopefully you can benefit from that instead of it being the way that it was. Even if it means I got to leave you alone, then I guess I leave you alone. I would prefer to give you 20 years of good time instead of 10 years of bad, like I don't know. It's out of my control. I give it all to God. He's going to be the only one that decides what happens with me in my life. You know who I am. I see what I've done. I see what I've caused. And I know how to fix it. Not for you, not for them, for me. Because I deserve to be a better person and you guys deserve a better person. That's simple. You deserve a better husband. You deserve a better man. And you deserve a better friend than what I had been to you. And I can be that person. And I know it. I am going to be that person. Oh, I won't bother you. I left you alone all weekend intentionally. I'll try to give you a few more days before I call you back again. You sort your own stuff out in your own head. My cigarette's still in the truck, I hope.
Yeah,
When I get out, I still gonna have cigarettes?
yeah,
Are yours still, you took yours, right?
yeah.
Okay. Well, if there's any way that I can get you some money while I'm in here, I will try to get you some money, okay?
You need your money for you.
Huh?
You need your money for you.
No, I'm fine. I got everything I need. It's my job to take care of you. You're still my wife. If I can help you, I will help you. It's that simple. You know, that's my job. And if I'd have done my job correctly, I wouldn't be where I'm at now. And I know that. Okay?
You're not there because you didn't give me money.
Huh? Do what?
You're not there because you didn't give me money.
I understand that, Doc. That's not what my self-worth comes from providing for my family, or it did. Not no more. But that's where it did come from. I've spent a lot of time analyzing who I am, why I did a lot of things, the things that I had been through. And when I get out, I would love to sit down and have dinner with you and talk about just spend days. I'm going to buy Mom's motorhome. I think, I don't know. I hope I'm going to buy Mom's motorhome and I'm going to go and just exist for a little bit and take a little trip and just drive around. We'll be the gypsies. Something that we'd always dreamed about doing. I'm not talking leaving state or doing any of that because I can't, but I can drift from area to area and just kind of exist. And it don't have to be to get high or any of that kind of thing. Just to be. Enjoy life the way it's supposed to be enjoyed. Food, friendship, love. A lot of things going on in my head, and I would like to discuss them with you. Really, really would. Unfortunately, I had spent so much time worried about just getting us high and doing those things that we missed the life. I missed life.
Yes, you did.
No, I don't want to miss that no more. Because you were right. And I was wrong. I see it. But anyways, lunch is gonna be here in about 5-10 minutes.
This is good food.
I'm not eating today, I'm fasting. Praying. Trying to cut some weight. Trying to get rid of the jiggle in my belly. I'm working out every day. Every day. No more stomach in the way. So when whoever puts their head in my lap, they don't have to put it on my fat belly. They can actually just put it in my lap.
Larry.
What? Tone, ready. Ready for the physical things that I need to be able to do. And I'm sure you can read into that. We were two physical beings that really enjoyed each other's company. We did sit-ups, push-ups, and sit-ups, and push-ups, and sit-ups, and push-ups, and tone. Now I'm trying to cut 15, 20 pounds. That don't matter. The physical attributes doesn't matter. It's the mental aspects of all of it that really matter. So anyways, thank you for taking my call. Thank you for talking to me. Thank you for listening. I hope you hear and understand me.
Not crying.
It's been constant since I've been here. About everything. Mr. Mrs. You. Your Mr. Mrs. is a little one. I miss my wife. I miss my friend. I miss myself. But I found him. I found him. You'll see him when he gets out. If you let me come and see you, come and see me, however it works. I'll be who you need me to be. I guarantee you. I'm not going to swear on God or any of that kind of thing. I'll promise you I will be who I'm supposed to be for you. I will make up for the last 10 years. Given the chance, I will make up for it. Treat you like the queen you're supposed to be. All right, I gotta go. I love you. I love you. I love you. I love you. I hope you have a good day.
Bye.
Bye.
Third call, this would be November 23rd.
Your Honor, just for a clarification, there are, at least I've received 5 calls from November 23rd.
This is the one at 10:02 a.m.
This call is being recorded and has a maximum call length of 30 minutes.
Morning.
Hello.
Hi. How are you?
I'm right.
Yeah. What's going on with you?
Nothing. Covering at the moment.
Yeah, that's funny. That's what I've been doing too.
Yeah.
Yeah, I colored you some pictures.
Did you?
Yeah.
Ouch. Oh, my leg went numb.
Yeah.
Mm.
Sorry.
Not your fault.
I know. Still sorry. See, I colored you a few pictures. Thinking back to simpler days.
Yeah, things were a lot different.
Huh?
The things were a lot different.
Yeah, I know they were. Simpler days. So just reflecting. For sure.
It's not like I couldn't see the writing on the wall. We were pretty hostile.
I'm sorry.
It's not like I should have seen the writing on the wall. We were pretty hostile.
Well, it don't have to be that way. It don't have to continue that way. That's for sure. Either way. Either way. All right. Well, I just wanted to call and say hello. Let you know I was thinking about you. Hope you're okay. Hope you made an appointment and got yourself some new glasses.
I did.
Good.
They're 20% off.
Yeah?
Yeah.
20% off.
Yeah, that's the insurance.
Okay. So how much were you able to actually get them?
I haven't got them yet. They're $100. That's without
Okay.
transitions.
Really? Blue Cross Blue Shield?
Yep.
Really? So somehow.
It's not your old insurance.
Huh?
It's not your old insurance.
It's not my work insurance?
Nope.
Huh. That'll make no sense. Really don't make no sense. When I get out, I'll get it figured out. I should have work insurance.
That's $100 without an exam or anything.
All right. Well, I'll see if I can get somebody to give you $100. You can get your full glasses. Okay.
I'll get them. I will start work tomorrow.
Huh?
I'll
thought
get
you
them
already
and start work. Well, I went to training.
Huh?
I went to training.
Oh, okay. Well, I'm not sure what you're doing. You're not said anything. We've not really talked, and I've been avoiding any of that. Trying not to pressure you, letting you be who you are, and I'll be who I am. And let's see where we can go from there. I'm still your friend.
Oh, you know my opinion on that.
Yeah. Well, your opinions change, and I can prove differently. Okay? Don't hold that. Please, just give me a chance here.
Haven't I done that before?
Okay, let's get stuck there too.
Not being stuck, really.
Okay, then don't. Don't. It's your choice. Okay?
I just know I've done this before.
No, we haven't. I've never been where I'm at now. Have I?
No, somehow no.
No, I've not been where I'm at now. And if you don't think this has changed me and I've seen and had a chance to really reflect, I have. Did you get my message? My mom died?
Yeah, I asked Tyler and he said not that he knows of.
No, Carmen passed away. My mother that raised me from the age of 5.
I told Becky it raised you for years and years.
Becky wasn't until we were teenagers. I didn't meet Becky until I was 13. Carmen was my sister's mother, who I had in my life until she was killed. So anyways, my lawyer's trying to get my sentencing date moved forward.
Yeah.
To the 1st. Yeah. We're just waiting. Hopefully the PSI pre-sentence investigation is completed and given. If that's done, then the sentencing can be moved forward. So I'm not sitting here on dead time.
Right.
Sheriff Good Days. I actually get an out date and all that kind of stuff. So maybe I can, I don't know. We'll see what happens. It's all on the judge. But like Chris or Mr. Parks told you, what you have to say will definitely influence what happens to me. So I guess if you want to see me sit for longer and you feel like punishing me more, then you can. Well, that's
I haven't punished you at all.
Okay. If you don't think me sitting here not wanting to being able to talk to you is not a punishment, you are my. I guess it's me punishing myself then for what I did. How's that? Regret and all the other things that I've been going through in my own head. All right. Well, I won't bother you. I'll call you sometime, maybe next week or next month or whenever. I hope you have a good day. And I love you. Talk to you later. Bye.
Bye.
All right, any additional proofs from people?
No, Your Honor.
Okay, as to the contempt question, any additional proofs from the defense?
No, Your Honor.
Okay, argument on the contempt, Mr.
Not much argument. He wasn't supposed to talk to her. Clearly he did.
Okay. On the contempt question, Mr. Parks?
No,
like you didn't contest that there was the contact.
There's no contest that there was contact, Your Honor.
Okay. Well, I guess based upon that, I'll issue a judgment of contempt and find Mr. Goddard in contempt of court. The show cause looks like was signed on December 15th by me. So from that date till now, he's got more than 93 days credit on that. So I'll give him, we'll enter a judgment of contempt, 93 days jail credit for 93 days served. Okay, so then we can move into the sentencing. Mr. Parks, have you had a chance to review the pre-sentence report and information with your client?
I have, Your Honor, and I also did receive back on January 27th an updated jail credit.
Yeah, it looks like if I were to calculate through to today, I'm getting 149 days.
I've got 155, Your Honor.
155.
Because there was 98 as of what would have been the first or the next hearing, which was. Apologies, Your Honor, I'm pulling up my calendar.
Got 65 as of January 5th, and then I added another 84 from January 5th to today. Agent Lesky, did you recalculate?
I have 154, Your Honor.
154, okay.
The 155, if you were including today.
I was including today, I'm sorry.
Okay,
Yeah,
and
so
the DOC doesn't count the sentencing date because that counts as a day he's serving the sentence.
Correct.
Okay. Then I have 154, Your Honor, from the last date that we received an update.
Okay, great. 154, any objection to that date, Mr. Virgo?
They're gonna count them better than I am, Your Honor.
Okay. All right, so we got 154 days credit. Other than that, no additions, corrections. Any additions, corrections from the people?
Yes, Your Honor. Well, the no additions or corrections, but objections, Your Honor.
So as to the scoring, it's at 0 to 11 months. Any challenges to the guideline scoring, Mr. Part?
Not from me, Your Honor.
Okay, and Mr. Virgo, any scoring challenges from the people?
The people would give scoring challenges to OBs 1, 3, and 19. Would you like me to go all at once or take them piecemeal?
Let's do one at a time. So as to OV1, that scored at 0 points. Go ahead with.
Your Honor, the people believe that OV1 should be scored at 20 points for exposure to an incendiary device. In the incident narrative, the description on page 2, it would be the description of narrative section 1, 2, 3, 4th paragraph down. We indicate that the victim indicated that she was held at gunpoint and there was a can of gasoline that was brought into the residence, threatened to pour it on her, light her on fire. If that weren't the case, Your Honor, then we would also get 50 points for a firearm pointed at her. There was a firearm pointed relative to any McGraw issues. Your Honor, defendant was in possession of this firearm the entire time. McGraw tells us that while it is OB1 is an offense specific, it is any conduct that happens during the commission of the crime. Defendant had this rifle the entire time. People v. Chlemicki examined where during a unlawful imprisonment claim, the defendant had brought a victim into the apartment and pointed a BB gun to her head. Because she was still unlawfully imprisoned and couldn't leave at that point, it was upheld that scoring for the pointing of the gun to the head, though it wasn't a firearm in that case, was appropriate. I do believe that it would be appropriate to score this for the incendiary device again at 20 points here.
Okay, so Mr. Parks, the prosecutor is saying that OB1 should be scored at either 20 points. Well, I mean, I'm going to dismiss that out of hand. The 20 points I don't see because even accepting the information PSI that he brings in the gas can and threatens to set her on fire, she wasn't subjected or exposed to an incendiary device. As I read that, so I wouldn't sustain the objection for the 20 points.
Okay.
But as the prosecutor says that we should score at least 15 points for a firearm being pointed at or toward a victim, or the victim had a reasonable apprehension of an immediate. Okay, I'm sorry. A firearm was pointed at or toward a victim. What's your response as to?
Your Honor, I would object to the score. I think the scoring is appropriate at 0. And the reason I state that is, Your Honor, there was never testimony from the victim in this matter. We have a police report that would be hearsay evidence just on its own, Your Honor. She never contacted anybody from probation to corroborate the story. At this point, it is a uncorroborated statement made by the victim in this matter, and the victim's not even here to even give a statement to corroborate what she stated. If that were the case, we would have to believe everything that's in a police report that's ever written. And Your Honor, I don't think in this scenario there's any actual evidence that the gun was pointed at her. Even the night where Mr. Goddard is at the home, the first incident, they never find a weapon at the home. It's not until they get an anonymous tip from Mr. Goddard's stepkids who are at the home while Mr. Goddard's not even been there for 5 days that they say, oh, while we were searching the laundry room, we found a weapon. And then the police are able to go in and get the weapon at that point, even though it's not been proven that the weapon was even there at the house during that incident.
Well, his description of the offense was, I was attempting suicide and my wife stopped me.
Well, then that would be on him, not on her. There's no proof that he pointed the gun at her.
You just said there's nothing to indicate the gun was present, but his own statement.
Well, in regards to her, then, Your Honor, there's no statement to say that he pointed the gun at her. Clearly, his statements wouldn't be hearsay as he's explaining his events of that night. I don't think you can score anything. I mean, maybe 5 points on OB1 if the court is going to grant some change to it, as the weapon would be displayed against himself. So if the court's willing to go that far, I think 5 points would be the more appropriate if the court's not going to go with 0, as we don't have any definitive proof that the weapon was ever actually pointed at her.
All right, well, to clarify my earlier remarks, the statute does define gasoline to be an incendiary device. I'm just finding that the victim was not subjected to or exposed to it. Perhaps if there had been some kind of attempt to splash it upon her or something, I would certainly do that, but I'm not sure the mere presence of the gasoline can would constitute subjecting or exposing her to the substance.
If I may, Your
To the
Honor.
device, yeah.
I would just argue that exposure is the threat of it, because there are also explosive devices. It would seem that the legislature wouldn't have wanted the actual exposure where the bomb doesn't have to go off, if you will, or the dynamite doesn't have to be touching the victim. If they think that they could be blown up or lit on fire, which with a can of gas in the room could happen, I do think it would be exposure, Your Honor.
Your Honor, and under People v. Ball, actually, the Supreme Court says that, the Court of Appeals actually states that OV1 is the actual use of that weapon. And People v. Ball, there's a incident where somebody died from a heroin overdose in this scenario, Your Honor, and the Supreme Court said, yeah, use of that heroin does not constitute a harmful chemical substance because they're nonetheless lethal doses, as this case demonstrates, is capable of causing deaths and therefore a harmful chemical substance. Nothing in MCL 750-200 HI restricts the definition of harmful chemical substances to those substances that are lethal all at dose levels. We do, however, agree with the defendant that it was not under the facts of the case used as a weapon. So even in that case where they're saying that heroin was the reason for the person dying, it wasn't used as the specific weapon in that scenario. So by that definition, Your Honor, I don't think you can score 20 points for OV1. I would agree 5 would probably be the maximum that you could score on it, as Mr. Goddard stated that he was going to kill himself, but I don't think that there's ample evidence to show that he ever actually pointed the gun at her.
All right, well, now I have heard argument from both sides on that. At first, I dismissed the prosecutor's contention as to the 20 points out of hand. But then after that, I see the statutory definition: incendiary device includes gasoline or any other flammable substance, a blowtorch, firebomb, Molotov cocktail, or other similar device. So clearly that doesn't require that it actually be detonated, just that has to be present. You're exposing the victim to that incendiary device, similar to pointing a firearm at somebody. It doesn't say you shot them. This is saying, you get 25 points if the firearm's discharged, but just pointing it is 15 points. So, I think 20 points, the victim is subjected or exposed to an incendiary device. Was this victim subjected or exposed to gasoline? You know what? And she says he held her at gunpoint. He brought a can of gasoline inside their residence. He threatened to pour it on her and light her on fire. And then when the police go in there, they notice a metal gas can sitting on the floor like the one that she described. I think after hearing arguments from both counsel on that, I do find a preponderance of the evidence that the victim was exposed to the incendiary device of gasoline. Over 20 points. I would indicate for the record that I also give credence to the 15 points for a firearm being pointed at or toward a victim. That was what she had described in the uncontested portion of the PSI. And then the defendant just denied that there was any gun there at all. Then later the gun is found. And then in his description of the offense, you can infer from his statement that he admits the gun was present.
Your Honor, may I?
Statement is, well, I heard argument from both sides and I'm making my ruling, right? So shake your head all you want, but that's how it proceeds. I hear from one side, I hear from the other, I make my ruling. It's not a debate.
Yes, Your Honor.
All right, so if I didn't score it at 20 points, I would certainly score it at 15, but I'll score it at 20 points. All right, Mr. Wirgo, as to OV3.
As to OV3, Your Honor, I do believe it should be scored at 5 because of an injury not requiring medical treatment. That same paragraph I referenced for OV1, she does indicate that he punched her all over and she did have bruises. She did not seek medical attention, and I would concede that just the bruising doesn't require medical attention.
All right, Mr. Parks, your response?
Your Honor, my client also stated that those bruises were from a BDSM session they have a signed contract that showed that they did that, and those bruises are not from that night, they are from a previous session. So to conclude that that is where the bruises come from, again, I believe is inappropriate at this point, Your Honor. And I still believe that it's appropriately scored at 0.
They pled to a domestic assault, right?
But that's not what the sentencing offense is at this point, Your Honor, for the PSI. That would be the felon in possession of a firearm.
What's the factual basis for the domestic violence?
Your Honor took the factual basis and said that having the firearm and pointing it at her was enough for the domestic violence. To put her in the apprehension of harm, or apprehension that harm was going to occur to her.
Well, I mean, that alone would have supported the 15 points then, if he pled to a charge that the factual basis included he pointed a firearm at her, wouldn't it?
I would agree with that. I conceded 15 or 5, Your Honor. But
well, you never conceded 15, did you? I didn't hear you concede 15.
I said it could be 5 or 15, Your Honor. Okay. I was arguing more for 5.
Okay. Mr. Wirgo, rebuttal argument.
No, Your Honor, just on my original argument.
Well, I mean, in the possessing of this firearm, it's in the context of right, the victim reported that defendant had punched her all over, and she showed the officer bruises on both sides of her body. That happened while, in the course of this offense of possessing the firearm, pointing it at her, threatening to shoot her, threatening to pour the gasoline on her and set her on fire, and punching her. The defendant gives an alternative explanation for the bruises, but that doesn't negate the ability to find that he's pled to the possession of the firearm and also domestic assault under those circumstances where the victim did suffer physical bruising. I would score OV3, physical injury to the victim, at 5 points. Mr. Wirgo?
As to OV19, I have a 2-pronged argument, Your Honor. One being that the testimony that the audio that we heard shows an interference with the administration of justice. We don't have it in an absolute contractual nature. I offer you this in exchange for this, but we have promises of a future life. He'll be better providing a truck. I'll get you that $100. And then we have go write the letter. This will change my time. I think that is interfering with the administration of justice. He's trying to influence a witness for the PSI. He even specifically references the timing of the PSI and how it will influence that. Also, Your Honor, on a separate and distinct argument, when interviewed, the defendant swore up and down there was no gun. He never touched it, but yet he went ahead and then pled to possession. So I believe that would potentially rise to the level of mere just denial that we would normally see, and would be an active attempt to influence the officer's investigation.
All right, Mr. Parks, as to OV19, your response?
Your Honor, it's appropriately scored at 0. You never heard anything on any of the recording saying, if you do this, I will do this for you. You have a husband who's asking his wife for a second chance. He's telling her that he's a changed man. He's being better. He's completely changed for the better. He's never offering to do anything for her in any kind of exchange for a quid pro quo or anything like that. He's saying that he's got insurance. He's helping her get her glasses because he's still obligated to, as her husband, to pay for her glasses in that scenario. He's not saying that you can't have the truck. He actually is saying, I'm going to give you money to help with the truck, as she just started a new job. She even said that on one of the audios.
Yeah, I don't hear a connection on a quid pro quo by preponderance, but I am wondering about would it be attempting to interfere with the administration of justice, asking the complaining witness to write a letter of support. In particular, in the third call, when he says, you know, what you have to say is going to influence what happens to me. If you want to see me punished more, then don't do this.
Your Honor,
Kind of laying on a guilt trip to write something to help her.
And those are just straight facts. She could have called the victim advocate, and the victim advocate would have said the same thing to her on the phone. Just writing a letter is going to either influence you one way or the other, or it's not, depending on how the letter is written. He's not saying, I want you to write all these good things about me. In the second video, he even says, I'm not trying to sway you one way or the other. If you think I should be in here, then I should be. He's not telling her, say these things so I can get out of here. He's not interfering with her at all. He's saying, if you would, you can. She has that right as the victim anyway.
Right. Well, she would have the right to recant as the victim, but if a defendant is contacting her pre-plea, for example, and saying, I want you to go write a statement that this didn't happen, that would surely be scored, right?
That would be completely different than what we're asking for today, though, Your Honor.
But so just the fact that the victim could contact the victim advocate, you know, here, but that's not how it happened. It's the defendant contacting her and saying, you know, I'm not trying to, he does say, I'm not trying to push you or influence you either way, but then he says, just write a letter for me, something positive. So it seems like he's trying to influence a victim impact statement. That seems pretty clear. He's trying to influence a victim impact statement. So
he's not doing it to his benefit or his detriment, Your Honor. He's telling her one way or the other.
But
so I don't see how
that's... Just write a letter, something positive.
He also says you can go one way or the other, Your Honor. So he's giving her the option. He's not telling her specifically, write this for my benefit. He's telling her, if you think that I deserve to be in here longer, tell them that.
If you want to see me punished more, so I think
exactly
which I think that the totality of those circumstances, I do find that he's trying to influence a victim impact statement to make it positive. I think that's pretty clear. And just him saying, you know, making a statement, I'm not trying to influence her one way or another, is that doesn't insulate him from all the other stuff he says. You know, I go to a delicate, you don't have to keep
I'm not
everything you disagree that I say. This seems to be a constant issue with you, Mr. Parks. It's okay to disagree with the court and with the judge, and I might be wrong. What you don't get to do is show outward, expressive disrespect. As a licensed attorney, you're an officer of the court.
I apologize, Your Honor.
All right. I expect I don't have to correct that again. This is the second time I've told you that in your practice in front of me. There won't be a third. It'll be contempt. You know, if I walk into a delicatessen and say, nice story you have here, I'm not going to do anything to hurt it, but it'd sure be a shame if something happened here if you didn't, you know, do this or that. You know, me saying I'm not going to do something doesn't insulate all the other statements. So I think that there's clearly evidence here that he is trying to influence a victim impact statement. My question to you is, as a matter of law, would that be interfering with the administration of justice? Because he's not trying to get a victim to say recant. He's just asking for something positive at the sentencing. And does that fit the parameters of OB-19?
In my opinion, it does not, Your Honor.
Okay, Mr. Wirgo, why would they, if I'm not, I'm not finding sufficient support for your quid pro quo theory, but I do find, based on the calls I heard, that the defendant, in violation of a court order, was contacting the victim and doing so in a way seeking to influence the victim's victim impact statement to his benefit. Would that support a score for OB-19 or not?
I believe it does, Your Honor. I gave a quick 15-minute look for case law directly on point, could not find any. I think that sentencing is where the justice happens, Your Honor. Adjudication is just one point of it. Pre-trial issues is just one part of justice. When we look at theories of punishments, they're rooted in justice, so many of them. Maybe not so much, you know, the rehabilitation prong, but deterrence and you know, the community, if you will, bloodlust. I can't remember the proper term for that, but Your Honor, justice is the sentencing. So I believe that in that aspect it would. And then if the court disagrees, again, Your Honor, I would ask you, and even that if the court does agree, for a ruling on the issue of the lying to the officer relative to never having possessed.
So, Mr. Parks, I haven't heard your position then on the alternative scoring for OB-19 at 10 points for the defendant lying to the police about the gun being present. Would that support a score of OB-19 or why not?
I don't think it would, Your Honor. I mean, just because you tell the officer, there isn't one. People tell officers all the time, nope, I've not been drinking. I don't have any open containers of alcohol in the car. And then lo and behold, they find one and they're not getting scored for interfering with the administration of justice, Your Honor. I think it's a stretch to say that lying during the investigation or not being fully truthful about it would constitute that. Clearly, there's a charge that the prosecution could have charged him for with that, and they dismissed it. So that's
right, but that doesn't mean that we don't get to consider that for sentencing purposes.
And it was considered, Your Honor, because that's why he got 10 points on OV10 for contemporaneous felonies that weren't adjudicated. He got 10 points for at least three for at least three other charges that he could have been charged with. So I think that satisfies where the other 10 points should come from OV19.
Okay, OV19 is for interfering or attempting to interfere with the administration of justice. The prosecutor contends that should be scored at 10 points for two reasons. I agree with both those reasons. First, the defendant, based upon the phone calls that we heard, is in violation of a court order of no contact with a victim of an assaultive crime, is contacting that victim and seeking to influence her statements to a court at sentencing. He didn't succeed in that, but he did attempt to do that. And that does interfere with the administration of justice, which does include what's the proper sentence to be given. And in my determination of that, I'm supposed to consider any statements that the victim makes. So any attempt to inject corruption into that process would support a scoring in 10 points. Alternatively and equally, I would score OV19 at 10 points for lying to the police officers about the firearm. The case law does support lying to the police to be at 10 points under OV19. It has to be something beyond just a denial of the crime. You know, I'm innocent. The defendant is allowed to protest his innocence, even deceitfully, without, or even he can protest his innocence even when he's guilty without scoring OV19. But here are the specific statements about the gun, and it is found, and it's found, you know, with the hammer cocked and one around is chambered. The way the hammer was in a cocked position, the action is closed, and there's a live cartridge that's chambered. So for both those reasons, I would sustain that objection. I'd score OV19 at 10 points. All right, so that adds 35 points. That would bring the total OV to 45 points instead of 10 points. And on the E grid, that would put us at OV level 4 rather than OV level 2. At C4, he's at 5 to 23 months. Is that right, Mr. Virgo?
It is, Your Honor.
Mr. Parks, do you have any objection to my calculation of the range based on the rulings?
No, Your Honor.
All right, so the advisory guidelines are now scored at 5 to 23 months. Mr. Parks, go ahead with anything you want to say in your comments.
Thank you, Your Honor. Your Honor, I think what's important here is what's happened since the incident occurred. Mr. Goddard is a completely different person than who showed up into my office saying that he was being charged with these crimes. Mr. Goddard is, since being sent to the jail, is now a temporary trustee. Depending on how today goes, I would request that the court either grant him the ability to remain a trustee if he is going to do some more time. And the alternative, Your Honor, what we have here is somebody who deeply loves his wife, believed that he could contact her after the court revoked his bond, didn't seek my advice on that, but sought the jailhouse lawyers that everybody seems to have. And in those videos, Your Honor, that you heard, in no way, shape, or form is he threatening her. Is he telling her that, you know, if you don't do this, bad things are going to happen to you? He's a husband trying to reconnect with his wife. They've been married for 10 years now, going through a few rough patches throughout those 10 years. He clearly wants to still have a relationship with his wife. What the court should also take into consideration is the victim has been not involved in this case whatsoever. She didn't show up for prelim. She didn't show up, hasn't shown up today, has written no victim impact statement. In fact, the person here on behalf of her is her mother, but she's here for my client. She supports my client in this situation, Your Honor. She is like a mother to him. He's already lost 2 mothers.
She's the one sitting directly behind him. She's shaking her head right now, indicating negative.
Well, that was the information I had going in today, Your Honor. So Mr. Goddard is still attending church with the guys in the jail on Sundays. He's praying more than I've ever seen him pray before. Me and him have prayed together. He's doing everything that he can possibly do to make himself a better person. Your Honor, he's jumped through all the hoops that he's had to while in jail at this point, to the point that they're making him a trustee. And I can't speak for more than what I've seen in the change in Mr. Goddard. He loves his wife. He wishes that they could fix things. I'm not sure, what the future looks for them, but I can tell you this is not the same man that was here in the courtroom almost a year ago at this point, Your Honor. The guidelines did change to 5 to 23, pending any appeals or anything, Your Honor. It is up to the court to determine whether or not he's prison bound or whether he's going to do some county time. Your Honor, I would subject to you, he's already done 154 days as of today. I believe when we were here last time, the court said that he was going to do at least 6 months on record. So he's already done more than that. He's got good time from being in the jail so far. I think his stint on probation that he should get should certainly alleviate any other issues that the court would have for Mr. Goddard. And I would just ask that you sentence him to time served at this point and let him do his probation that he's scheduled for 2 years as recommended in the pre-sentence investigation report, Your Honor.
All right, thank you, Mr. Parks. Mr. Goddard, is there anything you don't have to make a statement today? If you don't, I don't hold it against you, but you're welcome to make a statement. Is there anything you want to tell me, sir?
Made some mistakes in the past, Your Honor. I was angry. I had some issues going on. I've dug deep. I found what my issues were myself, and I was not honoring my wife. I didn't cherish her like I should have, and I realized where I've gone wrong. I plead for your mercy. Thank you.
Thank you, sir. Mr. Wirgo, any recommendations from the people?
Your Honor, a felon took a 30-30, put one in the breech in battery, pulled a hammer back, pointed it at his wife, grabs a gasoline can, brings it in, threatens to light her on fire, beats her, and can't really think of anything else that makes him a more dangerous human being. He received a substantial benefit of the plea bargain. He's not facing the consecutives on the felony firearm. I think that he at least deserves the full 23. Your Honor, I think that there's even room here for the court to exceed. Definitely think he deserves the maximum. Thank you.
Thank you, Mr. Goddard. If you please stand for the court sentence. Goddard is 56 years of age. He has 1 prior felony that disqualifies him from having a firearm. It's got 9 prior misdemeanors. In this case, he's pled to felon in possession of a firearm and a misdemeanor domestic violence. The advisory guidelines are 5 to 23 months. In this case, I have to look at the circumstances of the offense and the offender. The prior record is not doesn't really display a history of assaultive behavior. So that goes toward mitigation. And then I also look at the circumstances of the offense. He's convicted of being a felon in possession of a firearm. So if he's out, say, hunting or target practicing in a law-abiding way, but for the illegal possession of the firearm, he would still be convicted of the same crime. I mean, the guidelines would be different to be sure, but you have to take into account the seriousness of this offense. This is not just sort of a vanilla, it's a felony for you to possess a gun. What you did with that gun while you possessed it is very, very troubling. With a round chambered, pointing it at somebody, threatening them harm, threatening to burn them alive. beating them. This is a very troubling incident, and I understand the defense disputes, some of the ways that's been characterized, but that's the information we have. That was the report that's made. I think that's a terrible situation. That's not just cherishing your wife. That's putting fear into her, and it's terrorizing somebody. So, if I just focus on that, I'd be agreeing with the prosecutor at top end or even beyond, given the circumstances here, taking full credit and full account of some of the mitigation in that there's no prior assaultive crime. I think on the whole, the sentence will be as follows. I already issued the contempt sentence. There's state costs in this case of $118, crime victims assessment of $130, and court costs of $350. On the domestic violence charge, I'll order he serve 93 days in jail with credit for 93 days previously served. And as to the charge of felon in possession, Mr. Goddard, I'm going to commit you to the Michigan Department of Corrections for a term of not less than 18 months, nor more than 5 years, and give you credit for 154 days previously served. That's a sentence within the advisory guidelines, and it's not at the top end. I believe that it's proportionate to the circumstances of the seriousness of this offense, and the offender is outlined here today on the record. Mr. Goddard, if you wish, you can file an appeal to the Court of Appeals to challenge the conviction of the sentence for both. You can ask for an attorney if you want. If you want an appointed attorney, you'd have to ask for within 6 months of today's date. We're going to ask you to initial one copy of this, copy of your appeal rights. So we have a record we gave it to you, and the other one is free to fill out if you wish to take an appeal. Stand adjourned.
We will go on the record in the matter 25 CF 119, State of Wisconsin versus Dolores Corbine. The state appears through Assistant District Attorney Jose Vila in person. We have Dolores Corbine, who is in person. Her attorney, Nicholas Davis, is by video conferencing with approval of the court. We're set here today in this matter for a plea and sentencing hearing. Is this matter proceeding as such, Mr. Davis?
If you allow it, Your Honor, it was to be a deferred agreement, and I have gone through it with my client. I have gone through a plea questionnaire, waiver of rights form, but I do not have them signed and e-filed. But if you would like to put it on the record, I know that you're very thorough, but my client is ready to go.
I would actually at least need, at the very least, that deferred, and I need to have her sign it.
If the state has a copy, I went through it with her word for word, and she would just need to put her signature on it.
I can send a message back or go get a copy if the court can briefly adjourn.
All right, Mr. Vila, why don't you send a message and see if you can get a copy? We can adjourn Ms. Corbine's and we can proceed with Mr. Belial's while we wait. Back on the record, same appearances as previously noted, 25 CF 119, State of Wisconsin versus Dolores Corbine. The parties have reached an agreement. Ms. Corbine, your attorney is appearing by video conferencing, and you see him over there on the left on that big monitor. Are you okay with him appearing by video?
Yes.
Do you understand you have the right to say, you know what, Judge, I want him to be right here with me in the same room?
Yes.
And are you waiving that right today?
Yes.
If at any time you have any questions or concerns and you need to speak with your attorney, let me know and I will either send you to our Zoom room or I will have you give him a telephone call, okay?
Okay.
All right. So the parties have reached an agreement. Mr. Davis, can you please recite it for the record?
Your Honor, the agreement is my client is going to plead guilty to count 1, possession of narcotics. She's going to enter a deferred agreement for 12 months. And as part of that agreement, she understands that she's going to be bound by all her non-monetary bond conditions. She's not to commit any crimes. She's to, if she changed her address, she's got to contact the clerk of courts within 48 hours. She gives up any right or defenses that she may raise. She waives the right to a jury trial or any motion if she did not complete the agreement. She is also to comply with performing an AOD assessment and any follow-through and provide that to the district attorney's office within 90 days. I can inform the court that she's already done that and is currently in treatment, so I'll be providing that to the DA's office immediately. She's to pay a $150 administration fee within 60 days of today's agreement to the district attorney's office, and she understands that. And if she's able to complete everything, Your Honor, the state may make a motion to vacate it and dismiss the case.
All right, Ms. Corbijn, is that the agreement that you've reached?
Yes.
I have in front of me the deferred judgment of conviction document. Is this the document your attorney went over with you?
Yes, it is.
And you've had the opportunity today to reread that agreement prior to this hearing, correct?
Yes.
And you have reread it, and that's exactly what your attorney went over with you. Did you sign it?
Yes.
And Mr. Davis, if you could just please electronically file your signed page so we have the complete document, okay?
Before the day's finished, it'll be completed, Your Honor.
Thank you, Mr. Davis. So Ms. Corbijn, how old are you?
26.
And you can read, write, you understand the English language?
Yes.
Any drugs, alcohol, or other medications in the last 24 hours?
No.
Any mental illnesses or disorders?
No.
Do you understand that you would have the right to a trial? You would have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have a jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights?
Yes, I understand them.
Do you understand that by pleading guilty today, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Is she pleading guilty to possession of narcotics with the modifier or without? It doesn't state that it's with it in the deferred judgment, so.
Yeah, I'm fine with having this be the exact same as her co-defendant, which I believe for that one we did with.
All right, so you're asking the court to amend and remove the modifier?
Yes, Your Honor.
Granted. All right, so Ms. Corbijn, do you understand the state would have to prove on or around August 3rd, 2025 in Burnett County, Wisconsin, you knowingly possessed fentanyl, a controlled substance in a Schedule I or Schedule II, which is a narcotic drug without a prescription. You understand what the state would have to prove?
Yes.
You understand the maximum possible penalty of this felony could be a fine of up to $10,000 or imprisonment of up to 3.5 years or both.
Yes.
Do you understand that the parties are asking the court to accept a deferred judgment of conviction document, but I don't have to. Do you understand that?
Yes, I understand that.
I could sentence you to that maximum possible penalty if I thought it was warranted. Do you understand that?
Yes.
Do you also understand that this is a felony, that should you be convicted of this crime and sentenced, that you would no longer be able to use or possess a firearm for life?
Yes, I understand.
You would no longer be able to vote in any election until your civil rights are restored.
Yes, I understand.
Now, did you go over the criminal complaint with your attorney?
Yes, I'm aware of it.
And the facts that are alleged there of what happened that day and why you were charged with the crimes?
Yes.
For the most part, are those facts accurate?
In the criminal complaint, yes.
And so you're admitting here today you in fact did possess fentanyl without a prescription?
It was in the possession, yes.
Yes. All right. Together with co-defendant, you all of the things, and you're admitting to that, correct?
Correct.
Okay. Mr. Davis, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing?
Yes.
And voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
He has.
Has he looked at this matter thoroughly?
I believe so, yes.
And he's looked to see if you have any defenses or a lack of defenses.
Yes,
Are you satisfied with the services?
yes.
Do you have any questions for this court or for your attorney before I proceed?
No, I do not.
As to count one without the modifier, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count one, the simple possession of narcotics, drugs, and I felony. As to count two will be dismissed and read in for purposes of sentencing. Mr. Vila, argument.
Thank you, Your Honor. So just to briefly remind the court of this case, this is a situation where law enforcement EMS got called out of suspected overdose. Ms. Dolores Corbine was the subject who was on the ground when EMS was treating her first set suspect overdose. I think the crux of this case here is that this is a personal abuse situation. I think hopefully this was a wake-up call for Ms. Corbine, and as such, she's been doing treatment to try and continue to work on her sobriety. The idea behind the deferred here is to give her that additional layer of incentive to earn her way out of the felony, but to keep working on that track towards sobriety. I think this is the joint recommendation is appropriate, and I would ask the court to follow. Thank you.
Mr. Davis.
Thank you, Your Honor. Your Honor, this was a wake-up call for Dolores. I can tell you that on her own volition, she got herself in a treatment. She had her assessment. She's working a program. And Your Honor, she's also employed, and she's doing very well. And so she's on track, and I believe that she will take advantage of this opportunity. And I believe that she's going to earn her way to not have a felony conviction. So I'm very proud of her, and she needs to be proud of herself today. Thank you very much.
Thank you. Ms. Corbine, anything you want to tell me? You want to let me know?
Just that I am taking this situation as an opportunity to better myself. I know you've seen me a couple times in here throughout my adulthood. But yeah, this is just definitely, like they have stated, a wake-up call. And so far, I am doing really, really well, and I plan to keep moving forward.
Ms. Corbine, I don't want you to die.
Yeah, I don't want to either.
I don't want you to die. Your babies don't want you to die. I have seen you. I've seen you at your worst. Okay. I have seen you at your worst. I see you at your best. I saw you at your, what I thought was a great high and a great best when you were in treatment, when you were working with your baby, when you're doing those things and making those steps and making the right choices. I don't know what happened that got you to this black and white. I don't know when you came out of treatment and you were then on your own and trying to work through the steps and work through life. I don't know what interfered with that. I don't want to see that happen again. You're a nice and kind young lady, and your kids really, truly need you. They need you to be not only alive, but they need you sober. They need you present. They need you strong, emotionally, physically, mentally. They need you to support them. And you're doing very well. And I'm glad to see that. I want to see you continue to thrive, not survive, thrive. Okay.
Yes, thank you, Your Honor.
And so I think that this agreement is appropriate. So what I'm going to do is I will accept the deferred judgment of conviction. You have $250 posted. So what I'm going to do is I'm going to, I don't think that we forfeited it. I think I still have it. So what I'm going to do is I'm going to direct the clerk, send 150 to the DA's office.
Okay, so that's already paid then.
That'll be done.
Okay. Oh, thank you.
I'm trying to help you thrive. Okay.
Appreciate that.
And that's, I don't do this with everybody. Okay. Because just in case this falls through and then I have the money to help pay for the court costs and fees. But I want this to be a positive thing to you, to show you I believe in you, Miss Corbine. Okay.
Thank you.
Believe in yourself. Care for yourself. All right.
Thank you.
Care for yourself. So $150 will go to pay your $150 fee. Have you done your AOD assessment recently?
I had one done back in September when I went to treatment. I was currently in treatment in residential, went to a sober living, started doing outpatient up in Superior, Wisconsin, but had it transferred to Mille Lacs, the substance abuse department.
And you're still doing that?
Yes.
And so, Mr. Vila, so she knows exactly what she needs to do. Does she need to do another AODA assessment? Because it sounds like when this happened in August, then she redid one and she re-entered treatments and she redid those things.
I just need the documentation from the initial one. She doesn't need to go through that entire process again.
So get that documentation as quickly as you can, give it to Mr. Davis, okay? Because then the only thing that's going to be kind of hanging over your head is remaining sober, doing those things, and crime-free for 12 months and doing your steps, because then everything else will be taken care of.
Okay.
Okay? So I'm accepting the agreement. Please do that as quickly as you practically can. So then one thing is off your shoulders and then the other thing, okay? Then you just concentrate on you, making sure you're healthy and doing what you need to do, okay?
Thank you.
All right, so I think we're good there. Anything further, Mr. Vila?
Not from my perspective, Your Honor.
Mr. Davis?
I've got the documentation with regard to the AODA, and I'll get that to the district attorney's office too.
Then you're good to go. Mr. Davis is on top of it. Thank you, Mr. Davis. So get that and your signed paper, and I am good with you and good to go. Thank you.
Thank you very much, Your Honor. Thank you, Dolores.
Thank you.
We are adjourned.
We are adjourned, she says. Are we adjourned? Is that how it goes? Do I know what I don't know what button to press. I don't know what I'm doing anymore. Give me just a second. I can't pay attention to you. I'm busy. I've got other important things going. Hey, don't look at me like that, Felix. Hey, Julie. Hi. Look at the chat. Look at the chat. Hey, chat. How's it going? Ladies and gentlemen, thank you so much for hanging out with me tonight. It's been amazing. We started the night off with Judge Stevens, who had a little bit of a case we've seen some of before. A case we'll probably see some more of later. We'll find out. We'll find out what happens on Wednesday. I hate to predict what happens. Anyway, yeah. These cases have been one thing after the other tonight. And that guy arguing with Judge Dad about coming in on the warrants he had. And then that fella in Isle Press. Oh my God. It's rare we see like a psychopath or sociopath like that, right? Here. I'm here. The puppy's there. I've been chasing them around. The whole thing after dark happened. Thank you, everybody. I'm your lone wolf Usul. I am the humble curator here at your court gallery. I'm the guy who puts together these little videos and has these little get-togethers every single night of the week where we look at some of the best court cases of the day. And it all happens right here. And there's a lot more than this that happens, ladies and gentlemen, and you'll be seeing things drop all week long. First thing in the morning, every day at noon, and at night. Nighttime is for us here. Same Wolf time, same Wolf channel. What time is that, ladies and gentlemen? What does it say, chat? What is that time? I think it's 8 p.m. Central, 9 p.m. Eastern. I'm pretty sure. I gotta look it up. I'm not positive. Anyway, guys, it's been a thing. We're going to do another thing tomorrow. I have lots planned. So, yeah, 9 p.m. Eastern. 8 p.m. Central for all the cool kids. That's what I say to all my guild mates. We'll see all you guys later. I am your Lone Wolf Boozle. I have been so happy to participate with you guys in chat and put these little videos together for you. But for now, well, kind of, sort of. I mean, if you know, you know. For our final moment of wisdom, thanks to Ferris Bueller's Day Off, I just want to remind everybody that gravity cannot be held responsible for people falling. Good night, all.